Hello everyone. Thanks for joining us for the Building Your Practice with Special Needs Trust webinar. My name is Barbara Kotler and I'll be your moderator for today's program. This webinar is being recorded and the link will be sent out to everyone on Monday. We will have a Q&A session at the end of the webinar, so please enter your questions into the GoToWebinar panel located on the right-hand side of your screen, and we'll address as many as we can at the end of the presentation. I'm very excited to be joined by James Creel from Capital First Trust Company. James has 30 years of experience in the financial services industry, including banks, investments, insurance, and trusts. As a trust consultant for Capital First, James works closely with settlement planners and trust attorneys to establish trust solutions that protect clients from wasteful dissipation of settlement funds and provide income security, liquidity, and growth over the client's lifetime. I'm also pleased to introduce Bernie Crooks. He's the founding partner of the law firm Littman Crooks and chair of its Elder Law and Special Needs Department. Mr. Crooks is a nationally recognized expert in all aspects of elder law and special needs planning. And with that, I'll turn things over to Bernie.
Thank you very much, Barbara. And as Barbara mentioned, the title of today's program is Building Your Practice with Special Needs Trusts. And I thought we'd start out with the first slide, Erica, on what is a special needs trust, and in particular, what is a trust. You all probably have accounts in individual names and joint names, and you probably have some accounts where there's a trust that owns the property. In order to have a trust, you need to have a trustee, you need to have somebody who creates the trust, and then you need beneficiaries. The beneficiaries are the people who get the money from the trust, either during their lifetime or on the death of a certain person. So the difference between a special needs trust and a good old-fashioned regular trust is with a special needs trust, one of the beneficiaries of the trust, or more than one, has special needs. And what that means is, for some reason, they're unable to perform some of their activities of daily living. They were injured at birth, there was a medical malpractice accident, there was a car accident, or some other type of developmental disability. And the individual needs assistance with some of the functions of activities of daily living. Now, you may say to yourself, as a wealth advisor, you know, why does this matter to me? Why is this important? Erica, are you going to move the slide? Why should I care about this? And you know, the answer is clients are not going to care what you know until they know that you care. Clients want to know that you care about them and their families. And for families who have individuals with special needs, there's nothing more important to them than making sure that their loved one with special needs is taken care of. And this applies across the financial spectrum. We've assisted clients with estates in the 6 figures to clients with estates in the 8 figures. And all of them have different types of needs. But when you're talking about a family member with special needs, as an advisor, you need to understand that by addressing those needs, you can bring an extra value added to your practice. And as the account, I'm sorry? As the account, there we go, keep going. As the account transitions from one generation to the next, this will actually help you grow your business because you will have developed relationships. Can you mute your phone? You will have developed relationships with people in the next generation so that instead of losing the account to another advisor after a death or some other type of family situation, you can actually grow the business and expand it by being familiar with these kinds of trusts and these situations. Let's move to the next slide and I'll go over in a few minutes why people need special needs trusts and what the purpose of all of this is. For a lot of clients who have special needs, they receive many services from government agencies. And in order to qualify for those kinds of services, they have to look poor on paper, but can have money in other accounts, but the accounts can't be in their name alone. So it has to be in the name of this entity called the Special Needs Trust. And then the trust will pay for things that the government agencies don't pay for because the type of care and support that individuals receive from government agencies is not the Taj Mahal of healthcare or other type of support. It's bare bones. So these trusts are used to supplement and make better the quality of life of individuals with disabilities and their families. And without overgeneralizing, there are pretty much three different kinds of these trusts. And James will get into in a little bit more detail why it's important to distinguish among the different kinds of trusts. But basically, those trusts that are created by the individual with disabilities himself are called first-party trusts. And the person with disabilities can come into money from a malpractice settlement, a car accident, an inheritance, a whole host of ways. And if that person puts money into the trust, it's called a first-party trust. For some of those individuals who don't have an appropriate person or entity to serve as trustee, they can put the money into what's called a pooled trust, and these are run by various not-for-profits. And the avenue for wealth advisors to get involved in these kinds of trusts is if you develop relationships with the local not-for-profit agencies in your area that are serving as trustee of these pooled trusts, then they could perhaps turn to you with respect to any investment issues that may have, because they're going to be responsible for managing all this money that is being pooled together in these pooled trusts. And the third kind of special needs trust, which is probably the one that you'll come across more often than the other two, is you've got a family that's got a child who has autism or some other type of developmental disability, and the parents or family members want to make sure that after they're gone, the person with disabilities can have the highest quality of life possible. So one way to do that, and you all know this, a great way to create wealth for people who don't necessarily have it now but have the need to create wealth, is to fund a trust with life insurance. So frequently we see people establishing third-party SNTs and purchasing life insurance, and then when the person passes away, all of a sudden there's this great deal of money in the trust that needs to be managed and invested. When you're representing a trustee or when you're investing money on behalf of a trustee, there are different rules that apply in terms of what the trustee is allowed to invest in. And most trustees are subject to the prudent investor rule, and they have to make sure that they're not investing in things that are too speculative because they're acting in a fiduciary capacity. But one of the differences between trustees of special needs trusts and trustees in general is that for some of the other types of estate planning trusts you'll see, there's not as much need for current income or principal because the trust is positioned for long-term growth. Some of these dynastic or generation-skipping trusts that you might be involved in are more of a long-term thing. Whereas with a special needs trust, not only is it important to have long-term growth, but the primary purpose of these trusts is to make expenditures for the benefit of the individual with disabilities. So when you're investing these assets, you need to make sure that there's sufficient liquidity to meet the day-to-day needs. So if somebody needs a new handicap accessible van, or if somebody needs a new wheelchair, whatever the case might be, you need to make sure that there's sufficient funds available to meet these day-to-day needs of the person with special needs. And then finally, whenever you're dealing with trusts, you need to be cognizant of the tax issues, because trusts, unlike individuals, are generally taxed at a much higher tax rate than you and I. And the federal income tax rates are compressed for trustees, where they will hit the highest federal marginal income tax rate at a very low level of income. It's about $12,000 or $13,000, where for a married couple, it's north of $400,000. So you can see how quickly somebody who's invested in trust assets would hit the top tax rate. So as an investment advisor, one thing you might want to consider doing is, if you make distributions, then the trustee gets a deduction for the distribution, so that won't be taxable. If you invest in tax-free bonds or other tax-free type instruments, then that is not going to be subject to tax. Or alternatively, perhaps you'd invest in growth securities that don't generate a lot of income and there's not a lot of trading in the account so that you don't have capital gains. That will be another way where you'd minimize some of the tax effects of having a trust. And fortunately, the Internal Revenue Code has some other unique tools in it, such as the grantor trust rules, and there's something called a qualified disability trust that will allow you to minimize the overall tax effect to the clients who are involved in these kinds of situations. All right, so I thought the best way to explain some of this stuff, rather than going through all of the legal mumbo jumbo, was to go through some case studies. So if Erica, if you'll flip to the case studies one more time, we can go over the actual case that I was involved in regarding Sally and Susie. Fortunately, we were not involved on the planning side because it wasn't done properly, but the clients came to us after the husband passed away. These were a young couple in their 40s, and he was a very, very successful businessman, created a company, ended up getting bought out, and had a very significant estate of just south of $20 million. It was about $18 million. So he got hit by a car and died. And because he was young, he had never gotten around to making a will. And, you know, by the way, that's another value-added service you can have for your clients. Make sure they have advance directives and healthcare proxies and living wills and powers of attorney and a last will and testament. Because, you know, you never know when time is up. So this guy died without a will, had a wife and two kids, two daughters. One was a typical child going through school, and the other one had numerous disabilities. And based on the laws of the state where this person died, this one happened to be in New York. We can go to the next slide, Erica, please. There's something called intestacy, which is a fancy legal term for what happens if you die without a will. So and all states have a law like this. If you die without a will, the government makes a will for you, and they decide who gets your property. And a lot of times, it's not necessarily the people who you would think, who you would want to get the property. Like a lot of people think, well, if I die, my wife will get everything. And it's not true. The wife will get a piece of the action, and the kids will get a piece. And that was part of the problem here. With an $18 million estate, the wife got about a third of it, and the kids got a third each. So there was a taxable estate here of $18 million. $6 million of it went to the wife, so that was subject, or the marital deduction was available for that, so there were no taxes on that. But then you had $12 million going to the two kids at an approximate combined federal and state tax rate of 50%. So there was a dilution here from $18 million down to $12 million, and that $12 million was subject to a 50% estate tax, federal and state, and there was a $6 million check written to the government. So the kids, instead of getting $6 million each, in effect got $3 million each, and for the child with disabilities, she happened to be receiving Social Security, SSI, and some other benefits that were means tested, which means that she wasn't allowed to have $3 million and still get those benefits. And those benefits were very important to her quality of life. So they had to hire us to go to court to ask the judge if he would set up a special needs trust because Daddy forgot to do so in his will. And they ended up spending a bunch of money on legal fees to get this trust approved by the court. And the reality is, while the trust was ultimately approved, the judge required it to include a provision that said at the end of the day, when the child died, the government had to be repaid for any benefits they laid out on behalf of the child. And that would not have been the case had Dad included such a trust in his will. So while we were able to accomplish the goal of setting up the trust for the child, it was not without a price, and the price being significant legal fees and the fact that there was a payback to the state. So let's go to the next case study, Erica, and then I'm going to turn the program over to James. Here's another case which was done right. Mr. Kramer had come to us with the same $18 million as the last estate. However, he came to us before he died. And what we were able to do for him was we were able to do some tax planning that included special needs trusts. And he had a choice. The special needs trust could be set up either in his will, or if he wanted to, in this case, he decided he wanted to, he could set it up during lifetime. And why would you set it up during lifetime as opposed to in a will? Well, one reason is if you've got $18 million and you want to do some tax planning and you want to make some lifetime gifts into the trust that will qualify for the annual exclusion or will take advantage of your unified exemption amount, then you need to do it in a lifetime trust. So he set it up in a lifetime trust, and then he had the decision to make of whether he wanted to use one trust or multiple trusts. And what I'm getting to here is he had 3 kids, and he wanted to provide for the kid with special needs. So the choice was, do you set up a separate trust for the child with special needs, or do you do one trust and give the trustee the discretion to pay money out of the trust for any of the 3 kids in the trustee's discretion? The benefit of doing one trust is you get the money set aside and you know it's only going to be used for that particular kid. The drawback of it is if you limit it to the amount of money put in that trust, then you can't go above that amount. Whereas if you do one trust for the benefit of the 3 kids, then the trustee would have the discretion to give each child the amount of money he or she needed to improve that kid's quality of life. Ultimately, he decided to do multiple trusts because he felt there was enough money there to take care of each kid, and they didn't want the trustee to be put in the difficult position of deciding how to carve up the pie. And that goes to the $64,000 question, who should be the trustee? There are trust companies that do this very, very well, and then there are those that do not. When you're looking for a trustee of a special needs trust, it is critical that you find a bank or trust company that seeks out this business and that is dedicated to it, because it's not only about investing the assets, it's about making sure that you're disposing of them properly so that you're making expenditures when necessary to include the beneficiary, to make sure that the quality of life is improved. And trustees have been sanctioned, had to pay money out of pocket for not doing their job properly. So if clients are asking you about this, make sure you learn about, and James can talk about this as well, the trust companies that are out there that hold themselves out as wanting to be in this space. And let's conclude with the final slide, Erica, where when we're talking about Mr. Kramer, this is not something you do on your own. We like to think we're part of a team of advisors. We want to make sure we've got the wealth managers on board. You need the client's accountant. You need the other advisors, the lawyer, somebody who's responsible for making sure the insurance needs are met. And everybody's got to work together. There's a lot at stake here, not only with regard to the public benefits and the quality of life of the child, but there's significant opportunities here to save taxes. And if it's done right, you can hit a home run for clients. And what we have found, the wealth advisors that we've worked with that have developed relationships with clients and really connected with them on their family member with special needs have been able to represent those clients for generations and generations. It's one of those things where it's a bond that's pretty difficult to break. So I would encourage you to learn more about it. And at this point, I'm going to turn the program over to James Creel.
Okay, thank you, Bernie. I'm James Creel. I am a trust consultant for Capital First Trust Company. We're a company that specializes in managing trusts for people with special needs. It's what we do. It's pretty much all we do. And because of that, we're really just sort of uniquely different at the core of our being than most other trust companies you're going to run across. What I'd like to do is spend a little time talking about special needs trusts, our role, how we work with experts like Bernie, and how we can help you team up with people like Bernie and us to really create long-term solutions for your clients. Next slide, please. One of the things that's really important to understand Bernie talked about it. The proper administration of a special needs trust is critically important. One, if you do it right, which is what we do, it enhances the beneficiary's quality of life. If you do it wrong, it jeopardizes the client's government benefits, and then there are all sorts of legal problems. So when Bernie says it's important to pick a trust company that specializes in special needs trusts or has true expertise in special needs trusts, he's not kidding around. These things turn into lawsuits real quick if you don't deal with an expert. We are one of the trust companies in America that manages them on an everyday basis. We are one of the largest special needs trust providing trust companies in the nation. And I think what a lot of financial advisors don't realize is what a huge market opportunity this is. And one of the reasons why the opportunity is so huge is not only there are a lot of people out there with special needs, as our society has become more inclusive, more people with special needs sort of come out of the woodworks. It's not as shaming of a thing as it was 50 years ago. So you'll see people with special needs on a more regular basis. The other reason is because it requires tremendous expertise. Most financial advisors just don't even want to go there. They know they don't have the expertise. They really don't have the time to devote to it. And what I want to make certain everybody sort of walks away with is you don't have to be an expert to help your clients with a special needs trust. All you really need to do is have a team of experts like Capital First Trust Company and like Bernie on your side to understand your client's needs, help draft a good special needs trust document, and then a company that long-term will administer that special needs trust for you while you manage the funds inside that special needs trust. Next slide. The basics of a special needs trust. People have a special need. It could be a birth defect. It could be an injury. It could just be something like, Down syndrome, autism. It could just be dementia. And because of this, they receive special public benefits that non-injured or non-special needs people typically wouldn't qualify for. And the benefits tend to be SSI, not SSDI, which everyone qualifies, but SSI, Supplemental Security Income, and Medicaid. And these are state administered programs. And the Special Needs Trust is designed as a way to help your clients maintain those public benefits and their eligibility for those benefits, regardless of how much money they have inside that Special Needs Trust. And the Special Needs Trust then becomes a way to just supplement those benefits that they have. It becomes a great asset protection tool. Once you have funds inside a Special Needs Trust, that trust document provides special legal asset protection that other types of trusts do not provide. And then also the Special Needs Trust arrangement, if it's drafted by a true professional like Bernie, I would say there are experts and then there are true experts, and Bernie is a true expert. They can establish a Special Needs Trust or draft a document so that it is as flexible as it possibly can be to specifically tailor it to your client's needs. I really love working with Bernie's firm. I can't plug Bernie too much for how much help he's given us and how much we depend on him for his legal expertise. He's really a true expert in this industry. Next slide. You're going to hear a lot of things about special needs trusts, depending on the people you bump into, but there are two common misconceptions. But the one that is the most common is that the beneficiary is severely limited in what is available to them. And the thing to remember is a special needs trust is designed to supplement the public benefits they are receiving. And that's where people sort of think it's limiting, because there are things you can't spend the money on inside a special needs trust because you have to depend on Medicaid as a first payer in a special needs trust. But once we, as a trustee, go to Medicaid to find out what they can pay for or will pay for, won't pay for, then it frees us up as trustee to sort of fill in the gaps or supplement what Medicaid can't pay for. And it becomes a very it's really a very beneficial thing for a client with special needs, and for families, it really becomes just a huge comfort zone for them. As a financial advisor, you will find that your clients who you manage money for inside a special needs trust are probably much more grateful for the services you provide than a traditional wealth management client would be. Next slide, please. Now, there's a couple of things to remember. A lot of these people with special needs, they have future medical needs, and those medical needs are unclear. A lot of the reasons why people are establishing a special needs trust is to make certain that we protect those government benefits, so those benefits are available to pay for those future medical needs. Some government benefit programs also only accept individuals receiving SSI regardless of how much money a client may have or a family may have. There are facilities that depend on government resources for their funding, and they can only take clients who are getting those government benefits because that's how they get paid. And the Special Needs Trust protects those benefits and will allow your clients to get in like full-time care facilities that they couldn't otherwise get into no matter how much money they had. Next slide. What I want to talk about next, go ahead and flip over to the next slide, is I want to talk to you about how we can use the Special Needs Trust and our expertise to help you build your practice. You know, everybody in financial services is looking to gather assets. One of the things about a Special Needs Trust, there are two types of trust arrangement. One is called a traditional trust arrangement. That is where the trustee or Capital First, we would do the trust administration and we would manage the client's money. And the second one is called a directed trust arrangement or a delegated trust arrangement, and that's where the trustee delegates or directs the investment management responsibility to a investment professional like you guys, where we would do the trust administration, but you would do the investment management. So what a directed special needs trust allows you to do is it really allows you the opportunity to gather a lot of what we call sticky assets. These special needs trusts tend to be very, very long-term assets. I was working with an advisor and a client yesterday, and we were working on developing an income plan for a special needs trust that would provide their client income for the next 71 years. And it was really difficult, but we spent pretty much the whole day just talking to the parents about here's what we can do for your client over the next 71 years so that your child can have income to pay for their medical needs, their housing needs, that kind of thing, without touching the principal inside the special needs trust. And that's how long-term these assets can be. A lot of these special needs trusts, they will outlive your practice unless you're very, very young. The investment management duties become your responsibility in a directed trust. You sit down and just like you would with any wealth management client, you're going to talk to your clients about their financial hopes and dreams and their financial fears, and put together an investment plan that makes sense for them, meets their income needs. Because like Bernie talked about, there's a need for distribution on this because these people in special needs, they don't have careers. And they depend on the funds inside the special needs trust and the government benefits for how they provide for themselves for the remainder of their life. Next slide. Bernie touched on this. He talked about 3 different types of trusts. The first one, just to get this one out of the way, the pool trust for financial advisors is not a big opportunity. There are very few directed trust opportunities in a pool trust. The 2 that I think provide the most opportunity for you that we at Capital First administer are third-party trust, third-party special needs trust, and first-party special needs trust. And Bernie, I thought, did a great job explaining how they work or what the dynamics of it are. Third party is simply funded by a family member for a loved one. What you'll see most often, a family member will buy large life insurance policies for it to be funded at their death. Many will want to establish a special needs trust and name that trust in their will. Where having a will for all of your clients is a great way to uncover who has children with special needs. And some will simply, particularly where they're mental health issues will establish a special needs trust for their adult child to take care of that adult child while they are still alive. You'll find that is a very large opportunity for you that's just sort of hidden inside your portfolio that you've never really uncovered until you start talking about wills and estate planning and that kind of thing, which Bernie and his firm are experts in. First party special needs trust is what I work with a lot, and that is it's funded by the individual, and typically it comes from a settlement or a lawsuit where there's a personal injury lawsuit. A typical one that we see all the time are car accidents. Someone gets T-boned because somebody runs a red light. A person suffers a spinal cord injury and is a paraplegic or quadriplegic, and they wind up suing the person that ran the red light. That person has insurance. The insurance company pays a sum of money, and then now that person who's going to be a paraplegic for the rest of their life needs to maintain those funds for the rest of their life to pay for their future medical needs and their future life care needs. And that is another very large opportunity that a lot of people just don't see because it's sort of just hidden under the surface in our society. And I'll talk more about that in a minute. Next slide. Third-party trust, it's a family member that establishes the trust for a loved one. Family members that have children with special needs, I know we all know some, and you know how much those parents love their children, or how much grandparents love their grandchild. But one of the things that you should sit down and ask yourself is, do you have a client who has a disabled child or a child with special need, or a grandparent who has a grandchild with special need, or someone who has a relative, cousin or whatever, that has someone with special needs? And statistically, that is very, very likely. Next slide. We pulled these statistics off from the government statistics. 2 in every 7 American families report having at least one family member with a disability. That's incredibly high. And 1 in every 26 American families, they're raising a child that has some form of disability or special needs. There's a lot of talk in our society about autism. Sadly, in America, 1 in every 68 children are born in the United States has autism. We have a lot of trusts that we administer where parents have set aside money to take care of their autistic child. First party trusts, these tend to be in the court system. And it's a very hard market to penetrate. And the key to penetrating this market, it tends to be in your portfolio. And the question is real simple. Do you know a personal injury attorney or personal injury firm? And if you do, who's managing their settlement dollars? Typically, attorneys don't like to, attorneys don't want to be responsible for the management decision, but they do want to be responsible for educating their client on what their settlement investment options are. And the thing you want to listen to is, do they work with a settlement planner or do they work with a structure broker? If they work with a settlement planner, it's very difficult to work your way into that because that person is already providing a vast array of financial products. But if they're working with a structure broker, that is a good product to provide income, guaranteed income for a client. However, it does nothing to provide for a client's liquidity or emergency invasion needs or growth needs. And that becomes a great opportunity for you to say, well, look, I can partner with that guy, or you can let him do his thing, and I'll do the investment management portion to provide liquidity and growth for your clients. That's really where in the first party special needs trust, the opportunity lies is think about, do you know attorneys that specialize in personal injury? You see them on billboards all the time. You see them on TV ads. They provide a tremendous service for personal injury victims in our society. And that opportunity is huge. Next slide. This is how large this opportunity is. For special needs trust, what you're looking for is large settlements, but you're looking for settlements that are permanent and catastrophic. The reason why I was building a 71-year plan, 15-year-old girl has a traumatic brain injury, and she's never going to get better. Every year in America, there's $85 billion in settlements that go to spinal cord injuries or traumatic brain injury clients. Think about that, $85 billion every year. And according to Towers Perrin, that grows about 3% a year. That's how large the opportunity for you is. And the question is, how do you tie into those personal injury attorneys? Next slide. And again, I want to really emphasize this. You don't have to be an expert. Go ahead and flip over to the next slide. What we want to do is we want to be the experts on your team. I work with a lot of independent financial advisors. They're not experts in special needs trusts, but I become their expert, and people like Bernie become their expert. And we provide the expertise, and we educate you as we go along, and we educate your clients, and you learn as you go. But all you really have to say is, let me introduce you to my team of experts. We'll set up a meeting. You're the quarterback, and I'm just one of the players on your team, helping you develop the right trust solution for your client. Next slide. You need, and Bernie talked about this again, you need a trustee that doesn't dabble in this, that does this every day. And at Capital First, we're a trustee that does this every day, 365 days a year. A good trustee should work with you and your client in developing a distribution plan. These people need these funds to live on. They need to know that every 5 years they're going to need a new wheelchair, or they're going to need a handicap accessible van. Because we work in it, we will know things about where your clients can go to stem cell therapy for traumatic brain injury therapy, that kind of thing, that someone who doesn't specialize in this will know. We want to work with you to educate your client. And I had to say this, as we educate your client, we're also educating you. And it's just, the more we help you work with your clients, the easier it becomes for you. In the beginning, we're carrying all the water and you're just investing the money. But as you see, you guys are quick studies. As you see it done, it becomes a lot easier for you to sort of piece the moving parts together between a trustee, a trust attorney, care management firm, government benefits in different states. It really becomes a lot easier very quickly. We also help you and your clients, particularly we help your clients properly manage expectations of how the special needs trust works, what a trust for their sole benefit means, how parents can access funds for their child, how can, if a client doesn't own a home, how can we help them own a home and not count that as an asset towards qualifying for government benefits. And then we support the advisor and their investment plan. You're the investment advisor, we're the trust administrator. We work with you on things we've seen, but we want to support your plan, not dictate to you what the plan should be. You have the investment expertise, and you're also the local representative, you're local loyal like it should be, and it adds a lot of value to our practice. Next slide. Next slide. At Capital First, we speak the language of special needs trusts. We have over 300 special needs trusts, and our expertise and our experience exceeds that of most trust companies. Next slide. We have a staff of experts, three case managers, 10 trust officers, and 3 trust administrators. We also have trust administrators that are fluent in Spanish if you have Hispanic clients. Next slide. And key contacts at Capital First. I'm James Creel. There's my information. Dan Ermintrout also is an expert. And if for some reason you can't reach us, I would write this number down, 1-800-521-2359 for the main office. We have tremendous expertise in-house in our corporate headquarters. And it's not difficult to find someone who can answer your question, who can get you the help you need, who can guide you in the right direction. So if you run across a client, we'd be happy to help. feel free to give us a call. That's all I have.
Perfect. Thanks, James. I think we have some questions that we can go through now, if that's all right.
Absolutely.
Perfect. So the first question I have is there any reason for a special needs trust to be established for an individual who's over 65, or does it only make sense if they're younger than the Medicare age?
Bernie, I don't know if you want to answer that question.
Yeah, sure, James. Thank you. What the gentleman is referring to is, Jim so clearly pointed out the difference between a first-party special needs trust and a third-party special needs trust. The law provides a cutoff. If you want to set up a first-party special needs trust because you had a car accident or there was a medical malpractice and you are the person with disabilities, you have to be under age 65. However, if you want to set up a third-party special needs trust for the benefit of somebody other than yourself, so a parent for a child, an aunt for an uncle for a nephew, a friend for another friend, there are no restrictions on that. So that's a major difference between a first party and a third party. There's no age limit on third-party special needs trusts.
Perfect. James, I think this is a question for you. Someone is wondering if you have a minimum trust size requirement for administrating a special needs trust.
Very good question. A lot of the trust companies that do special needs trusts have large minimums of $1 million on up. I know there's one that does $2 million on up. We will do a special needs trust for as little as $100,000 plus the first 2 years cash distributions. I know that's a little nebulous, but basically $100,000 we can do a special needs trust.
Perfect. I think this might be a little bit for both of you. If a special needs trust is created in a will and thus doesn't arise until the testator dies, who applies for the government benefits? Is it the trustee?
Well, first of all, the person could be receiving the government benefits before the testator died. In fact, that's quite common that they will already be on benefits. But if they're not, and there's no next of kin or family member, what has to happen is somebody has to become the legal guardian. Somebody has to represent the individual with disabilities if they're not able to do it themselves. So sometimes it could be the trustee. In other cases, there's a life care planner or there's someone else involved, like a social worker, who will help assisting with that. And James, I look forward to your input as well on this question.
Yeah, Bernie's right. Usually someone is already on public benefits before the special needs trust is established. So usually that issue has already been taken care of, but we can help, we as trustee can help someone. Also, we work through a couple of national and worldwide organizations called National Care Advisors or Broadspire that we can bring in a case manager or a care manager that can help clients qualify for benefits. Like we just had a client move from North Carolina to Colorado, and we had to bring in a National Care Advisor specialist to help them establish benefits in the state of Colorado. It's really not that hard. We can, but either it's done or we can do it with the expertise and the connections that we have.
Great. The next question, can you comment on the use of ABLE accounts for special need clients?
Yes, I'm happy to do that. This is a relatively new tool in the toolbox that's been around for less than 3 years now, and it's been implemented in a couple dozen states now, and the states that haven't implemented it yet are either in the process of doing it or will be soon. There was a concern amongst many folks in the disability community that many individuals who have disabilities are relatively high functioning and are very independent on their own. And it was not fair for them to not be able to have a bank account of more than a couple $1,000s without sacrificing their government benefits. So this law was passed, and it got diluted, unfortunately, from what was originally intended. Allows somebody to have an ABLE account that can be contributed to the tune of the annual federal gift tax exclusion, $14,000 per year, and the money in that account will not disqualify the person for government benefits. So ABLE accounts are good for the small cases because at a $14,000 a year cap, you really can't put a lot of money into it.
and they're also good for cases. We've had a lot of cases where we've set up special needs trusts and also used an ABLE account because we wanted the child, the person, the individual to have spending money to buy things without having to ask a trustee. So we think they go hand in hand.
Great. Someone is asking, what happens if the beneficiary's health improves to where they no longer require the special need trust protections?
This is probably the most common question we get, especially in the third-party trust world, because while special needs trusts are a very nice tool to have, there are some restrictions on what you can spend the money on. And with respect to first-party trusts, you do have to file accountings with the court, and there are even further restrictions on what you could spend the money on. So if you have a family member with a mental illness where maybe it gets better, maybe it doesn't, or with some other type of disability where the future is not clear, the clients always want to know, can I get out of it? And this is where a good drafts person comes in. If you picked up a form on the internet or cranked something out of a word processor, it probably wouldn't give you an exit strategy. But if you went to an experienced special needs trust attorney who actually took the time to listen to you and understood what your needs were, you can absolutely have a way out. And in many cases, the way out doesn't happen until you pass away. So you're really putting that discretion in the hands of the trustee or trust protector or some other third party. But the short answer to the question is, if it's done right, you can get out of it.
Okay. This is kind of a two-part question. Are there different fee schedules and/or services for the special needs trust during the life of the settlor, assuming third party, and after the death of a settlor, assuming principally funded with life insurance?
Well, typically there's no administration or assets to manage until it's funded. So that's just, I think in the trust industry, we refer to that as future fee business. There really is no, the fee is established when you establish the trust itself. The fees would kick in when there's an actual trust to administer and there are actual funds to invest.
Perfect. Who is the beneficiary of a special needs trust when the individual passes away?
Well, that depends on what kind of trust it is. If it's a first-party special needs trust, then the government is going to have to be paid back for any goods and services they provided to the individual during his lifetime. And then usually the remainder beneficiaries are the estate of the individual. If it's a third-party special needs trust, then you can bypass the government. There's no requirement that the government receive any reimbursement. So you could name anybody like you would in your ordinary will. You can name the brothers and sisters, children, nieces, nephews, whoever the person wants the beneficiaries to be.
Okay. We have a question about, I'm guessing this is for you, James. Can you cross state lines? I'm guessing, can the trust be established by someone that's in a different state?
Yeah, each state has their own individual approval process. We can do multiple states. Some states we have to go to and get approval every time we do a trust. But yes, you can do multiple states, or we can do multiple states.
Okay.
The key, there are sort of two caveats to that. One, each state has their own rules. So in each state, trustees have to get approval, but we also need a Bernie approved in every state that is licensed in every state. One of the things we like working with people like Bernie, he's part of a whole network of people. And if Bernie can't do it, he can refer us to someone who can.
Great. This is another question. If a child receives a settlement, for example, from a malpractice at birth, can money in that settlement be used to purchase life insurance on the parent in order to fund a third-party special needs trust?
That is a terrific question, and this goes to the whole issue. If it's a first-party special needs trust and the money that's being used to fund the trust is the money that belongs to the individual with the disability, the law requires that that trust be for the sole benefit of that beneficiary with disabilities. So you can't spend trust money if it has ancillary benefits to other people. And the question of buying life insurance on the caregiver,
is really one of the hot topics in this arena. And I think the conventional wisdom now among the judges is that having a caregiver in place after the primary caregiver dies is critical, and that is an appropriate use of trust funds. But this is one of those things where you might want to get court approval, although I think the success rate across the country has been pretty high on this lately.
Great. We keep getting more questions, so we'll take as many as we can until the top of the hour, and then Capital First will get back to everyone individually that we haven't addressed. Another question is SSI a requirement for setting up a special needs trust?
No, absolutely not. Many people have that misconception. The type of government benefit that you get has no bearing on whether or not you're able to set up a special needs trust. It may influence the type of trust, but you don't have to be in receipt of SSI, although as James mentioned, many of our clients are receiving SSI, and not so much necessarily for the monthly payment that it provides, but a lot of them live in group homes or residences that are financed by the federal and state governments, and in order to get in to these programs, you have to have SSI. So that's why the misconception happens, but you can set up a special needs trust for somebody who's not on SSI if it was appropriate.
Perfect. This is a clarification from an earlier question. They just want to know, so the first party trust, you have to pay back the government benefits. Is that true?
Yes, so you may say, well, why do I want to do this if I just got to give the money back? And the answer is there's no requirement that there be any money back. So a 5-year-old gets, malpractice, goes to the doctor and has a malpractice suit and gets an award of money. To me, the perfectly administered S&T is the trustee writes a check for the last dollar in the trust the day before the person dies, and then there's no payback. So Medicaid can only be paid back out of the assets that are in the trust when the trust is terminated, and there's no obligation to preserve the assets for Medicaid, and there's no responsibility on behalf of the trustee, the advisor, the family member, or anyone else in the world to pay back Medicaid out of their own assets. So only if there happens to be money in the trust, then yes, the first dollars will go to Medicaid.
And it's only up to the amount of the lien that Medicaid would have. If you have a $5 million special needs trust and Medicaid has paid $1 million in benefits, their lien would only be $1 million. It's not like they get the whole amount in the trust.
Excellent point, James. Thank you.
Next question. Does their broker-dealer have to have a selling agreement with your firm in order to be able to use your services?
No, it's an individual arrangement. We don't have to have a selling agreement. We basically, as trustee, we direct the investment responsibility to you. It's actually drafted in the trust document. That's the agreement, but it's not a selling agreement with a broker-dealer like you would traditionally think. It's not like when you have to sell a variable annuity or something like that. Great.
This will be the last question. So since a first-party special needs trust requires a definition of disability meeting SS's definition, what is the definition required to establish a third-party special needs trust?
There is no requirement, and that's why the third-party S&T has a little bit more flexibility, because this is not necessarily a black and white area. It's gray. And what a lot of lawyers do is they'll draft a more conventional trust that, upon the flick of a switch, so to speak, converts into a special needs trust. It's like a contingent S&T, so that if it turns out the individual does have special needs, then you've got the appropriate bells and whistles in there. So for a third-party S&T, I can draft one for anybody I want and call it an S&T because the government's not involved in that. You may have to give the government a copy of the trust to review it if the person is applying for benefits, but there's no requirement or there's no need to meet the definition of disability for a third-party trust.
Perfect. James, Bernie, thank you so much for your time and your expertise today. Thank you, everyone who came to the webinar. As I said at the beginning, we've recorded the webinar and we'll be sending a copy of that recording to you on Monday, along with everyone's contact information. And we will address any of the remaining questions individually on Monday as well.
Awesome. Thank you.
Thank you. Bye-bye.
Bye.